Viewers need to know. How did this play out?
Well, Anna, at 9:55 a.m., a deputy called to order today's conference in the case of United States versus Comey and read the case number. But that fact that we started at 9:55 and not 10 a.m. as scheduled tells you everything that you need to know about the courthouse behind me. This is the Eastern District of Virginia, famously known as the Rocket Docket, where things move fast and early. And Judge Michael Nachmanoff's handling of this morning's arraignment was no exception to that. But what you really saw today was sort of a study in contrast. Pat Fitzgerald, the former U.S. Attorney for the Northern District of Illinois, over 12 years, spanning two administrations, Democratic and Republican, a long decorated veteran of the Department of Justice representing James Comey today, had many more words than people expected of the usually taciturn Pat Fitzgerald. And on the contrary, we heard sort of relatively little from the government. And that's because the government was represented in court today, not only by the U.S. Attorney Lindsay Halligan, who did not say a word to the judge, but by two new prosecutors that only entered appearances in the case this week, Tyler Lemons and Gabriel Diaz. They were brought in from the Eastern District of North Carolina, not the office that's adjacent to this courthouse or even across the river in D.C. That's because, according to reporting from our colleagues, there is no one in the Eastern District of Virginia that was willing to take on this case, a case that veteran prosecutors in this office recommended never be brought. We have a 2-count indictment charging James Comey with 1 count of misstatements to Congress in connection with some September 2020 congressional testimony before the Senate Judiciary Committee, and another much more nebulous count charging him with obstruction of Congress for additional false misstatements that are not enumerated in the indictment. So one of the discussions today was Pat Fitzgerald really asking the judge to make sure that the government is sort of meeting its burden to disclose what this case is even about. For example, who are persons 1 and 3 mentioned in the first count of the indictment? Also asking for paperwork relating to the appointment of Lindsay Halligan, the interim U.S. attorney. Why is he asking for that? Because he told the judge that he intends to make 2 motions right off the bat on October 20th. One, alleging that Jim Comey was selectively and vindictively prosecuted in retaliation for speaking out against President Trump. And secondly, because Lindsay Halligan, according to them, was unlawfully appointed as interim U.S. attorney, and therefore they need to see how she was appointed, when, and by whom. All in all, we have a trial date now of January 5th. Again, I mentioned this is the Rocket Docket, where things usually move fast, and sometimes even within that 70 days afforded under federal statute for defendants to have a speedy trial. Judge Nachmanoff was reluctant to let it go beyond the speedy trial clock. That would have set a trial of December 17th. But because of the defendant's own preference for pretrial motions and the government's representation about the complexity of discovery here, as well as the presence of some unspecified classified information, he said he'd be willing to let that trial date slide to January 5th. Whether we get there on January 5th is going to be a bumpy road between here and there.
Ken, you've been following this case from the very beginning and have been out front in the reporting about an indictment coming and what has transpired since. What stands out most to you about how things went this morning?
Well, I just think it's so interesting that James Comey's lawyers are telling the judge, we don't know what this case is about, really, because none of the rest of us do either. I mean, we have some reporting that suggests what we think it's about. It's about James Comey saying that he never authorized an FBI employee to be an anonymous source in the press. And this indictment contends that, in fact, they have some evidence that he did that. Although the key witness, apparently, a man named Dan Richmond, is not saying that. That's not his account, so he won't be a good witness for the prosecution. So again, it just raises a host of questions about why we're even here, why this case has been brought. And then I'm also just, one thing we haven't heard much about is the fact that James Comey, this wasn't just an arraignment. He surrendered today. And remember, we talked about this earlier, there were people in the Trump administration that wanted him to be arrested and perp walked. And a particular official in the FBI in the Washington field office said no to that and stopped that from happening. And that person has been fired. And so today, when he entered the courthouse, we believe, we don't have any information about this, that he would have been processed by the marshals and potentially fingerprinted and his mugshot taken. Again, this is the former director of the FBI, a former senior Justice Department official who firmly believes he's innocent and should not be in this courthouse. It's just a remarkable place we are in our country today.
Anna, can I add something to that to underscore the point that Ken just made?
Yeah. Go ahead.
In addition to the fact that originally the administration wanted to seek Jim Comey's arrest, usually at an arraignment, there are a couple things that happen. One is that the defendant makes a plea of guilty or non-guilty, and Jim Comey pled not guilty today. But the other thing that happens is usually there's a discussion about the terms of the defendant's release. And when Judge Michael Nachmanoff of the Eastern District of Virginia asked the government if they were seeking to detain Jim Comey pretrial, the answer was a very simple no. There were no disagreements on the terms of his release. He was released on his own recognizance, and there are very few limits on what he can do from here on out as a defendant. That stands in marked contrast to the fact that they wanted to arrest him with his indictment.
Former judge and former U.S. attorney Carol Lamb is with us, and you've been listening in. Carol, your take on all that has been disclosed.
Yeah, this is very concerning, Anna, because by the time we get to federal court, you like to think that there's some maturity going on. What's going on now really sounds like a preschool or kindergarten. You've got a government team that has not worked together, not worked in that district, not appeared before that judge, not worked with the FBI agents who are investigating the case. And that's a big concern. That's like having a surgical team that's never worked together before. The fact that Pat Fitzgerald, who is Jim Comey's defense attorney, has not only not seen the evidence in the case, but can't even figure out from the indictment what the charges are, is very concerning. This is, I'm not given to a hyperbole, but this is ridiculous. The whole purpose of an indictment is to give notice to the defendant about what the charge against him or her is. And the fact that somebody as experienced as Pat and even as experienced as Jim cannot figure out what the charges are, Judge Nachmanoff must be saying, we have moved into a whole new realm here of immaturity and lack of experience, and he's going to have to try to marshal this through a system that is used to people who are professional and know what they're doing. That is just not the case here. It's very discouraging. Thank you, guys. Stand by. Ken, thank you so much for being with us. Lisa, please do stay with me. I want to turn to Anthony Coley here at the table because a lot to digest.
Right.
Your initial impressions of how this went today.
Well, I think it's a sobering moment in modern American history. It's a watershed moment even. Not since Watergate, Anna, have we seen a president weaponize the Justice Department to go after his political rivals. Now, he talked about this in his first term, and even back in the campaign, you remember those chants, lock her up, about Hillary Clinton, but he had people around him who resisted his worst instincts. That's not what we have here. Now, big picture, I've been around Washington a long time. Generally speaking, there are two types of investigations that come out of Washington. You've got the criminal and the civil investigations that you typically see in the Justice Department, where you have, in those situations, you have FBI agents, you have investigators. They just follow the facts.
Yeah.
The facts and the law tell them where to go next. With political investigations, and we typically see this with political actors in Congress, right up the street, members of Congress, they start the process with the end in mind. And then they take a series of steps to try to bring about the political outcome that they want. And that's what Trump has done here. He has corrupted the Justice Department and put aside facts and law and replaced it with revenge and vengeful politics. That's what's going on right now.
Paul Butler, what do you see as this case being in terms of strong or weak? We had initial impressions when the indictment was brought, but given what happened inside the courtroom, some of the conversations that took place between the judge and the lawyers, does it give you any more confidence that this could be a legitimate prosecution?
I think this is an extremely weak case, Anna, and if you don't believe me, ask the prosecutors and investigators who investigated this case. Reportedly, Eric Siebert would have loved to have won this case on behalf of his boss, Pam Bondi, and the President of the United States, Donald Trump, who urgently wanted this prosecution. But the experienced prosecutor said if this case goes to trial, he's going to lose. And that's why he declined to bring it. His reward was he got fired by the President of the United States, who bragged that he was going to get the guy he wanted. And in order to do that, he installed this extremely unexperienced prosecutor to bring this high-profile very tough case. So to me, one of the most telling moments this morning was when the very experienced defense attorney for Mr. Comey, Pat Fitzgerald, said he was going to bring a motion for prosecutorial misconduct. Anna, that's a nuclear option for a defense attorney. It means that he or she believes that the prosecutor violated the law or professional ethical standards. It's usually brought when prosecutors are accused of presenting false evidence or withholding evidence. So this is going to be a heated battle, and I'm fairly certain.
Trump's pursuit of James Comey doesn't resemble justice. It looks more like apolitical vendetta wrapped in legal paperwork. From the moment this indictment appeared, the whole thing hassrire of retaliation, not accountability. What's playing out here isn't about enforcing the law. It's about rewriting it to settle old personal grudges and torment every critic that crossing Trump has consequences. Here's what's telling. Veteran prosecutors wanted nothing to do with this. The Eastern District of Virginia, known for its integrity and efficiency, couldn't find a single experienced attorney willing to touch the case. That silence speaks volumes. When career prosecutors, people who've handled everything from espionage to organized crime, all step back at once, it's because they see what this real is, a hollow case built on political spite. So, Trump's circle did what they always do. They went looking for loyal replacements instead of qualified ones. They dragged in prosecutors from another district, people new to this terrain, and seemingly unprepared for what they were handling. One of them reportedly didn't even realize she had already approved an earlier draft of the indictment. That's not strategy, that's disorder. A serious legal effort is built on discipline and detail. Trump's legal operations, on the other hand, thrive on confusion and chaos. The motivation couldn't be clearer. Trump has been obsessed with Comey ever since the Russia probe. To him, Comey represents the era when the Justice Department dared to act independently before it was turned into a tool of political control. Now surrounded by loyalists who echo his every word, Trump's finally doing what he's always wanted, rewriting the past by punishing those who defied him. The charges themselves barely coherent. The indictment reads like a rough draft, vague, clumsy, and strangely incomplete. Even Comey's defense team reportedly can figure out exactly what the government claims he did wrong. When an indictment can't articulate the alleged crime, it's not justice, it's theater. And the timeline makes it worse. The supposed false statements happened years ago, well beyond the statute of limitations. The entire case feels like a desperate performance meant to dominate headlines, not the courtroom. And that's the irony. Trump's orbit has been filled with officials caught lying under oath or to investigators. Yet, none of them ever faced this kind of pursuit. Selective outrage has become a political weapon. Legal scholars are already comparing this to Watergate, but even Nixon kept his abuse of power behind closed doors. Trump puts his on display, boasts about it, and dares the system to stop him. This case isn't built on facts. It's built on fury. Federal prosecutors are being transformed into instruments of political revenge. And even if this case collapses, as it likely will, under the weight of its own contradictions, the damage will linger. Every time Trump twists the justice system into a personal score-settling machine, the rule of law erodes a little more. What replaces it is dangerous.